And so let's talk a little bit about San Jose now, because there's requirements a little bit different. It's actually been through the first level of a lawsuit. Yeah. There was a ruling by a federal judge upholding this requirement that the city has put in place. Let's get into that one. What is that requiring exactly?
So that is much more limited in its requirement, and it does basically just cover, you must, if you are a gun owner, have insurance for accidental injury or damage. As I said, that is typically required by a homeowner's policy or a renter's policy. If you don't have either, you theoretically would be required to get some kind of coverage, either go get yourself a renter's policy or get some kind of standalone policy. It doesn't.
That's not how that started out, though, right?
Yeah, no, no, not at all. It started out,
and that's not how it was sold.
As a broad mandate that would apply to everybody, and that insurers would use their underwriting ability to weed out bad gun owners and charge more to those who are riskier. That's not the way it's
right. And it's coupled with a fee.
It's coupled with a fee
that's supposed to go to like a
firearm
nonprofit to offset the cost of gun violence is supposed to be the idea.
Yeah, they haven't determined what that nonprofit would be, and so until they do, I think the fee is on hold. Also, there is no unlike New Jersey, which says you must have $300,000 of coverage. San Jose's ordinance doesn't stipulate how much coverage. So I don't know if you have $1,000 of coverage, is that enough? We don't know, but that it seems on its face that it would be. And it also includes some carve outs. So law enforcement are not required to abide by the ordinance. Also, concealed
they don't ever have accidents.
Yeah, concealed carry permit owners are not required to abide by it either. But in a city of more than 1 million people, there are only 36 concealed carry permits in the city of San Jose. So that's a pretty small group. But what's funny about that is by exempting concealed carry, you've made clear that this is not about public carry, right? This is about ownership. It's, in fact, theoretically, people who do not carry the weapon who would have to buy the coverage. People who do carry the weapon theoretically have an exemption.
Yeah, the exemptions don't really make a lot of sense in the San Jose one, but especially because of course, that whole ordinance was sold as like a way of putting the costs of gun violence onto gun owners.
Yes.
Which, this one, it doesn't actually seem to accomplish this, but two, of course, it's very highly questionable whether that's constitutional. But there was, to be fair to San Jose, a federal judge who ruled it is constitutional, that it's okay. Now, they cited surety laws from the 18th century, from the founding era, as their guiding post for the historical tradition of requiring insurance to own firearms. Now, that's sort of the standard under Bruen is you have to find for modern gun laws. And these are two laws that have never existed before. Nothing, there was never any gun insurance requirements ever in any part of the United States to this point. But there were these surety laws. And the judge in this case said that they constitute a substantially similar historical law, and therefore it's constitutional under the Bruen test for San Jose to require this insurance policy to own a firearm. Can you explain to us a little bit about what these surety laws actually did? Because I think a lot of people are curious on that point.
Yeah, so a surety is technically a form of insurance. The purpose of a surety is to assure that a specific kind of performance will or will not be taken by the person who goes to get the surety. So the most common surety that people are familiar with is a bail bond. You go get a bond to pay. They put your bail up front. You pay them a certain amount. If you don't skip bail, then they get the money back from the court. The money you've given them is theirs. And if you do skip out, then they would be out the money from the court, and that's why they hire, bounty hunters to go get you. So there was something similar, a system similar to that, that actually goes back to Britain in the 1300s. And it involved knights who were marauding in the countryside. And so if you went to your local magistrate and said, there's this knight and he's disturbing the peace and waving his sword around, he could require, the justice of the peace could require that the knight had to go get a surety that for some limited period of time, in those days it wasn't a bond, it would be like, a wealthy landowner would agree to pay, that if he doesn't disturb the peace in this period of time, he's all good. But if he does, he has to pay. The surety is forfeit. So there were similar laws in colonial America and a couple of the colonies in Massachusetts and Pennsylvania. And then in about a half dozen states starting the early 19th century. Again, Massachusetts, Pennsylvania, I think Kentucky was one of them, that all were triggered by someone having a complaint. So really is more like a red flag law, like where you would say that this person is in some way a threat to public order. And that's why they would have to go get a surety. Again, it would be for a limited period of time. It's not a freestanding obligation of all gun owners, and it's not applied across the board. It's applied to specific individuals. The judge,
that's the big difference here. Right,
yeah.
Is that surety laws, did exist, and they are part of the historical tradition of gun regulation in the United States, and they're going to be a very significant part of probably a lot of Bruen analysis moving forward. But they were very specific laws that dealt with a very specific issue of somebody who is accused of being a threat to the public safety. I think, but you're describing knights. I think people maybe of a certain age at least might know the term highwayman, right? From the Willie Nelson, Johnny Cash song, where a highwayman was basically somebody who would just rob people as they traveled out of town. That was sort of the same idea as the roving band of knights. Obviously, we today associate knights with a totally different sort of aesthetic or we usually think of them as noble, good guys, but they could also be basically like gangs essentially that would rob people as they traveled around. And so there were laws like a lot of these laws are still relevant today because they came up in the 13th, 14th, 15th century, but they were sort of the catalyst for laws that continued well on into the 18th century, which is the relevant period for Bruen. And but they're basically people who there's reason to think that they might do something to harm others with the guns they want to carry or the weapons they want to carry. And so the response usually in this, of course, ironically, the response is, today, somebody like that who'd been convicted of, robbing somebody in a felony assault or something wouldn't be allowed to own guns at all for the rest of their life. Back then, you had to do something like put up a surety, which is a very different restriction. But either way, you see the specificity of what a surety law was and what it did compared to a blanket insurance requirement to own guns by literally everyone in the city of San Jose or anyone who wants to carry a gun. Or there's even, as you explained earlier, some ambiguity about who exactly the New Jersey requirement attaches to. But it seems like there's some fairly significant differences. Is that your reading?
That's fair. And also the Judge Freeman so she hasn't technically gotten to a decision in the case. She's had some preliminary orders. One was she denied
the temporary
denied a temporary restraining order. She has the main group that was challenging the law. She dismissed their claim, but with leave to amend, meaning they can now go back and amend their complaint, incorporating in particular Bruen analysis, which she got briefed on, but didn't consider that briefing the appropriate forum to hear Bruen arguments. But she did hear this argument from the city about surety laws and seemed, inclined to say that this seems analogous. But in her analysis, she says that the reason that it's analogous is that just as surety laws were fit to serve a particular purpose for an individual who's a public threat, that insurance companies will naturally gauge the riskiness of a potential policyholder and charge appropriate premiums fit to that policyholder, which is a nice theory. It's just not true. It's not. We have these homeowners insurance policies already. That's going to be the primary way people would satisfy the San Jose requirement. And typically, an insurance company doesn't even ask if you have a gun when it gives you a homeowner's policy. It's not something they've ever been interested in, because firearms accidents, they know they don't cover intentional damage. Firearms accidents are relatively rare. The stats I've seen are that firearms injuries, about 20% maybe, are accidental. Firearms deaths, it's 1%. So it's a small part of a claim, and that's all accidents. As I said, first-party accidents would not be covered. So if a wife and a husband have a dispute and there is an accidental discharge, one injures the other, not a covered policy. They're both first parties. Same thing if a child were to get a hold of a gun that is not properly secured, anything that happens there, he or she is a first party. So that's not a covered incident. So her theory is it doesn't look at the evidence whatsoever. It doesn't look at how insurance actually works. It just assumes that insurance companies will do this, but they don't. They don't do it. Yeah.
I mean, I think there's obviously a fatal flaw with that reasoning anyway, which is that you're trying to require insurance for someone to exercise a constitutionally protected right. It's very similar in my mind, at least, and I want to hear your thoughts on this, to trying to require libel insurance for anyone who wants to speak about politics in any form, whether it's attending a protest or writing online about your political opinions. At least libel insurance is something that exists, is a real thing you can get. A lot of writers have it. It protects you against libel suits. But, obviously, if a state or city tried to require everyone who wants to engage in First Amendment activities to obtain libel insurance before they do so, even if the premium for that would be minuscule because libel cases are not that common, it still wouldn't be constitutional, presumably, because it places a burden on the exercise of the right. Do you think that's a good analogy?
I think that's a good analogy. I mean, where we require by law liability insurance, it's not in areas that are protected constitutional rights. We require it of drivers. We require it of doctors that they have medical malpractice insurance. There are other instances, like we require architects to get errors and omissions liability, because if an architect builds a building and it collapses, that's a significant threat to public safety. But none of those are constitutional rights. You don't have the right to drive or be an architect or be a doctor. You have to abide by regulations and licensing regimes and all the other things that are different than constitutionally protected rights. Bruen is still new law, and so the standard of Bruen may be amended over time. It is a pretty broad standard to say, essentially, it's presumptively unconstitutional. Any restriction is presumptively unconstitutional, and then you have to prove, the burden is on the government to prove that there's something analogous. We'll see how courts interpret something like the surety requirement. I mean, it's not crazy that a court could find that there was a requirement for insurance and this is a requirement for insurance, and so there's an analogy there. I don't think they will, but it's in the realm, at least in the realm of debate, and that's what we'll see going forward.